Yes, Mr. Lord.
My Lords, just before the short adjournment, we were just looking at paragraph 56 of the Court of Appeal judgment, page 214 of the core bundle, and I was making the point that Lady Justice Rose has ignored, if I can put it like that, the first stage of the test, which is the need to find an intention to waive, which you do from an inconsistency. She puts the test even higher, in fact, than the second stage, which is the question of reservation, where she says, about 12 lines from the bottom, the client should be made aware, even though he's now been asked to grant security over the litigation recoveries on the terms of the new arrangements being negotiated with him, the solicitor will have a first call on those recoveries. That may be not saying much more than reservation, but she then goes on 3 lines later. It's essential that in making that choice, he has a complete understanding of what his solicitor's prior claim to the proceeds of the litigation will be if he continues to fight the case and thereby incur further fees, legal fees. That is what the solicitor is under a duty to explain to him, and why it is so important that the client understands that any monies he ultimately recovers are subject not only to the security he's now providing, but also to their pre-existing lien, which will continue in parallel. Now, my Lords, in fact, it is a 2-stage test, and I'm sorry to go on and on about this, but the first stage has been ignored, and the second stage, which is simply has the solicitor reserved his rights, seems to have been elevated to some kind of duty that there has to be a complete understanding of what his solicitor's prior claims are. And I made the point this morning that when a solicitor is engaged for litigation purposes, there's no duty on the solicitor to say to the client when he's first engaged, by the way, you do know all about Section 73 and my equitable rights. So, with the greatest respect to Lady Justice Rose, paragraph 56 is wrong. And just to wrap up on independent legal advice, as I explained before the short adjournment, there are 2 ways in which we put this. One is that we are in the identical position, in effect, to the ex-solicitors in Twig Farnell, and that certainly if you read Lord Justice Shyman's judgment, the effect of that is that there's no scope for waiver, and that's an end to the matter. Alternatively, the role of the solicitor and the reason why the test is any different for a solicitor arises only in the context of reservation. And on the facts of our case, where we've told the client and the client's acknowledged that we're not advising him, there's no reason for the solicitor to be treated any differently from the innkeeper or the banker. And my Lords, that's independent legal advice. If I can now move on to inconsistency. Your Lordships have seen the test as set out in the authorities, the 2-stage test. It's objective. The burden is on the respondents. But just before considering the specific matters, the 4 specific matters relied upon by my learned friend, I just want to step back and invite your Lordships to look at the big picture, what was happening on the ground here. This was undoubtedly large litigation. It involved a number of different jurisdictions, but the main dispute was centred in London. PHRL was not in a position to fund it, and there were no further third parties who could be asked to fund it. Therefore, if I can put it like this, the only game in town was Candey, and they were being invited to take a real risk, a substantial risk, by agreeing to the FFA. Their estimate of costs, if it went all the way to trial, was 5 to 6 million, and they were accepting 3.1 million. And therefore, it's not surprising that in those circumstances, Candey would want to take as much security as possible. And that's what Mr. Candey explains in paragraph 17 and 18 of his witness statement that we looked at before lunch. And further, the intention was to take a first legal charge, which would rank ahead of litigation expenses. And, my Lords, in my submission, in those circumstances, common sense, commercial sense, everything points to the fact that it is inconceivable, in my submission, that in taking the deed of charge, Candey intended to waive their equitable rights and their rights in due course, when there was a recovery, to rely upon Section 73. That's the sort of big picture, slightly jury point, but it is a really real point. One knows, not least from Lord Briggs's judgment in Gavin Edmondson, the purpose behind Section 73 and their equitable right is to preserve access to justice. That is what Candey were doing. They were taking a risk themselves to ensure that their client could have access to justice. And in my submission, all courts should be very reluctant in those circumstances to say that as a result of that, you have somehow lost your equitable rights. Now, my lords, turning to the four alleged consistencies. The first, relied upon by my learned friends and indeed by the Court of Appeal, is the taking of the security over the same assets as would be caught by a charge under Section 73. But of course, as your lordships know, the charge didn't simply cover the recoveries of the London litigation. It was a lot wider. It included all the assets and undertakings of PHRL, including shares, all monies in court in all jurisdictions, and all such other assets. It couldn't be wider. And there is no case where it has been held that the taking of security over different property amounts to a waiver. And there is no case where it's been held that the taking of security over different property, over the same and additional property is a waiver. And in my submission, there is no basis objectively to infer an intention to waive in those circumstances. What the cases make clear is what is meant by inconsistency is that there's some feature of the security which is incompatible with the lien, such that the two rights, to use the words of Mr. Nugent, so that the two rights cannot sensibly be intended to exist in parallel. Well, here, there's no problem with the equitable right and the deed of charge existing in parallel. Yes, there is an overlap. But that overlap doesn't allow, it isn't a reason for inferring an intention to waive the lien. It's just a belt and braces exercise. Candey were trying to, that they were helping their client, but they were trying to protect themselves, which they're perfectly entitled to do as far as possible. As for the cases that are relied upon by my learned friends and by the Court of Appeal, we've looked at them. Curry and Ray concerned a possessory lien over title deeds, with a mortgage being taken over precisely the same property. I'm not going to go back to the case, but as I explained this morning, the Court of Appeal didn't apply the correct test as set out in Retailer and Re Morris. And there's nothing in that case that suggests that on the facts of our case there would have been a waiver. Room and cheese right, as Mr. Nugent explains in paragraph 35 of the Solons, Mr. Justice Kekowicz applied the wrong test. The principle that he relies upon was wrong, albeit that on the facts of the case, where the solicitor himself drafts the charge, which provides for a trustee to be appointed, applies for the trustee to take the property, and provides for the trustee to be paid his costs before making any payment. In those circumstances, one can see, it's not the ratio of the decision, but one can see that there's an inconsistency. On the one hand, the solicitor is saying, here's the charge, the property will go to the trustee, he will pay his costs and expenses, and then he will pay what's left to me. And then on the other hand, he comes along and says, no, ignore that. I've got my equitable right under section 73. I come in at the top, therefore everything goes to me.
What's the effect of your floating charge?
My Lord, I'll come on to that. I'll come on to that when I'm not ducking it. I'll come on to it when I deal with priority, because I'm just dealing with the same property point at the moment. But, my Lord, rest assured, I will deal with it as best I can. So, my Lord, this is dealt with in paragraph 63 to 73 of the Court of Appeal judgment, which is in the core bundle beginning at 216. And groom and cheese right is addressed in paragraph 65. Facts are explained. 66. I accept Mr. Lord's point that it is not entirely clear from Mr. Justice Kekowicz's decision whether that was the factor that he relied upon, i.e. the same property, on when holding that the lien had been waived. Addressing the matter as a point of principle, the reasoning which led me to conclude that the solicitor's duty to explain the effect of the new security is not avoided by the taking of independent advice applies here too. The important point is that the solicitor is seeking to secure his future fees against the proceeds of the litigation in which he continues to act for the client. The client needs to be aware of the full extent of the solicitor's interest in those proceeds when it comes to considering any future advice about the prospects of success in the litigation, the wisdom of settling or accepting any payment in court. I do not regard the fact that additional security is also included in the new arrangement as affecting that result. Now again, with the greatest respect to the Lady Justice, now, Lord, that lady, this is the same error that we saw in paragraph 56. In effect, what she is saying is that a solicitor, if he is not going to be deemed to have waived, must make the client fully aware of the full extent of his interest in those proceeds, including his rights under section 73 and under the equitable charge. And that, I repeat, is simply not the test. It is the two-stage test. Now, my Lord, finally on this, whilst it's not necessary for me to make this submission good, in our submission, there is no reason why simply taking security over the same property, which is not our case, we've taken it over the same property and lots of other assets, but simply taking it over the same property would amount to a waiver. One can see that it might in the case of a possessory lien, because you are holding on to the title and then you opt for something else. But in the case of the equitable charge, why should taking an additional security amount to a waiver, per se? Just simply taking an additional security. It will just be a parallel security, which is exactly what Mr. Newgee is talking about in Solon number 1. And indeed, that appears to be part of the basis of the decision in Twig Farnell, because we've seen where Lord Justice Mummery says he agrees with the judges below that there was no inconsistency. But on the facts of that case, the solicitors had a claim for their fees, they got judgment in relation to that claim, and then sought a charging order, so that the charging order was on precisely the same property as the Section 73 charge would be. But as Lord Justice Mummery found, there was no inconsistency. So, my Lord, that's the same property. Now coming on to different priority. First of all, there is no case that suggests that a different priority itself can found the basis of inferring an intention not to rely on the lien. And I will come to Groom and Cheesewright. But there is no case. That isn't the basis of Mr. Justice Kekowicz's decision. Indeed, if that were the case, any further security would amount to a waiver of the lien, because the lien will always rank first. It's common ground between us that the lien is akin to salvage. It comes in right at the top. So even if there was a first legal charge, the lien would trump it and come in top. Therefore, if a different priority can found the basis for inferring an intention to waive, the taking of any additional security would amount to a waiver. And that is simply not what the cases say. They say the opposite.
Well, how would a first fixed charge be any different in terms of priority than the lien itself? I accept if you include the lien, it's bound to be second to the lien, but if it's held by the same person, that's...
No, if it's held by the same person, if Candey got what they thought they were getting, contrary to His Honour Judge Davis White, if they'd had a first fixed charge in relation to the recoveries, it would have been an academic argument.
Yeah.
I accept that.
And the judge wasn't saying that was the inconsistency. The Court of Appeal.
No, you're right.
Was saying it was because of the interposition of the litigation funder.
Absolutely right, my Lord. You can see that from the Court of Appeal judgments. Paragraph 72, having set out the arguments, paragraph 72, 4 lines down, she says, the equitable lien would always rank ahead of other debts according to the case law. To hold that the taking of any new security over the assets already secured by the lien amounts to a waiver of the lien would be inconsistent with Re Morrison Re Taylor, as discussed earlier. There is some force in that point, and it may be stretching reliance on Groom and Cheesewright too far. I therefore prefer to rely on the acceptance by Candey that their claim to the proceeds of the London litigation could be defeated by the prior claim of Campion Maverick. Yeah. So that's the, we call it paragraph 5 of the deed of charge point. Now this is addressed in paragraphs 91 to 96 of our case. And my lords, paragraph 5 is simply reflecting the commercial reality that exists today, where funders and ATE insurers insist on being paid first, at least for their capital outlay. So that where you have a commercial funder, it will agree to fund the litigation and will put forward a capital sum and will be entitled to all sorts of other things, other entitlements in the event of success. But it will insist that its capital outlay be paid first, ahead of a solicitor, ahead of anybody else, in relation to any recoveries.
Well, had Campion Maverick provided the money by this stage?
Nobody, we didn't know. These companies originally were run by Mr. Omar Amanat, who I believe is now in prison in New York. And everybody, including Candey, including the Liquidators when they came on board, were very sceptical of anything that had been done by Mr. Amanat.
My Lord, the situation is there was a pre-existing legal charge in favour of Campion Maverick. Subsequently, when the Liquidators investigated it, they found it didn't actually support any funding that had properly been provided. But there was a pre-existing document which was purported to be a legal charge.
I think really you need to let Mr. Lord is short of time, and you'll have a chance to reply.
I'm sorry. But what Mr. Holland says is entirely correct, and that no doubt is why the words "of any bona fide liability to Campion Maverick" was inserted in the deed of charge, because there was some doubt, even at the stage of the deed of charge, as to whether or not it was a genuine charge with genuine funds having been advanced.
But a solicitor's equitable lien would beat that by way of salvage.
Correct.
And yet you said it's an ordinary fact of life that even solicitors have to give way to litigation
yes.
funders.
I'm not talking about the facts of this case. I'm just saying it is, in my submission, an ordinary fact of life that if you go to a commercial funder to fund your litigation, or you go to an ATE insurer, they will insist on the first right, or the first rights to any recoveries. Now, if, therefore, paragraph 5 amounts to a waiver of the lien, in our case, it will amount to a waiver by solicitors every time they agree with a funder that the funder should be paid first. Because it will be...
Can I just give you an example? It's a straightforward case of a solicitor's lien. Everybody recognises it's there. Funder comes on the scene, says, yes, I will fund, but A, I want a first charge, and B, I want the solicitors to subordinate their lien to my charge.
Yes.
And the solicitors say, OK, we'll subordinate our lien.
Yes.
That's not a waiver of the lien, surely it's a subordination of the lien.
Well, and that's precisely, my lord, what we say the effect, precisely, that's what we say the effect of clause 5 is.
I see.
Because if you look at clause 5, PHRL irrevocably agrees and instructs Candey to act with full powers to ensure that any monies or benefits arising or payable in any court proceedings in any jurisdiction shall be paid directly to Candey towards payment and discharge of any liability pursuant to the fixed fee agreement prior to anyone else, save for repayment of any bona fide liability due to Campion Maverick. It's no more than what happens every day where commercial funders are involved. It is simply a recognition of the commercial reality. In fact, we submit that clause 5, and I'll develop this when dealing with reservation, is a reservation of the lien subject to recognising that commercial reality, and that Campion Maverick will be paid first for any bona fide liability. All Candey are doing, if you like, is postponing their lien to any bona fide liability owed to Campion Maverick. And my lords, can I just refer you to one case in this respect, which is in the authorities bundle. It's Barclays Bank against Estates and Commercial Limited. It's at tab 3, page 408. It's a judgment of the Court of Appeal, Lord Justice Millett. And I just want to take your lordships to page 415, where Lord Justice Millett is referring to the decision of the Court of Appeal. This is at G on page 415, in Kettlewell against Watson, where the plaintiffs were trustees of a charity. They sold land to Richardson and Watson, who were estate agents who bought the land. The bulk of the purchase money remained unpaid, and the plaintiffs retained the deed of conveyance. The estate agents sold the land to sub-purchasers who borrowed the purchase money by mortgaging their lots. The plaintiffs then brought an action to enforce their lien for the unpaid purchase money against some of the sub-purchasers. Much of the case is concerned with questions of reservation, etc. He then sets out passages from the judgment. My lords, if I could just invite you very quickly to just read page 416, and then the key passages over the following page. My Lords, over the page for 417, in my judgment, this was not a case where the existence of the unpaid vendor's lien was excluded. It was a case in which the unpaid vendor's lien was postponed to the equitable interest of the sub-purchasers because such a postponement was a necessary consequence of the way in which the vendors conducted themselves. A party with an equitable charge can be taken to agree to the postponement of his property against any party who is allowed to his knowledge to purchase the land on the face that it is unencumbered. Having allowed DIB to deal with the land on the footing their purchasers were selling as absolute owners free from the lien, now insisted on, the plaintiffs could not assert their lien against the sub-purchasers. I have little doubt, however, that the plaintiffs could have asserted their lien against their immediate purchasers, so that, for example, had the purchasers become bankrupt, their trustee in bankruptcy could not have sold the land to sub-purchasers and retained the proceeds of sale for the benefit of the unsecured creditors, but would have been bound to account for the proceeds of sale to the plaintiffs in satisfaction of the unpaid vendor's lien. The lien would have been overreached so that it attached to the proceeds of sale, rather than the land itself. It's in a different context. It's in relation to the vendor's lien. But in my submission, that is what has happened in Clause 5 of the deed is to precisely the same effect.
But correct me if I'm wrong, what you call Clause 5, which is the second unnumbered paragraph after 3, I think.
Yes.
Is part and parcel of this deed of charge.
Yes.
I'm not sure one would think, oh yes, now they're talking about their lien, just postponing the lien. It looks as if they're saying this is a first charge.
Yes.
But so far as concerns recoveries, it's postponed to the priority of Campion Maverick in relation to those recoveries. But there's nothing saying here, and by the way, so is our lien, which prima facie would not be.
You're right, my Lord, of course. It doesn't refer to the lien itself. No. But what we are considering here is not the question of reservation. We're looking at the question of inconsistency and whether or not there's a relevant inconsistency from which you can infer an intention to waive. And all Clause 5 is recognising is the commercial reality of the position, which is that if there is a genuine funder who has genuinely provided funds, then it is to be paid first. The question is whether or not from that fact you can infer an intention to waive the lien as against PHRL. And in my submission, you can't. You just step back and say, yes, of course, all they're doing here is recognising that the fund is to be paid first.
Well, I can quite see if the solicitors had already agreed to postpone their lien to Campion Maverick before entering into this charge, you might have a point, but there's no evidence that they did, is there?
There is no evidence.
No.
And the solicitors wouldn't be bound, would they? In the sense that if Campion Maverick had got a good charge,
yes,
and the Campion Maverick couldn't have relied upon this document to establish that the lien was postponed to them.
Campion Maverick couldn't rely upon this document because they're not parties to it.
No. So it would be totally ineffectual in postponing the lien to Campion Maverick.
Yeah.
Yes, yes, but I come back to the fact that what we are looking for is intention. Can you see from what we call Clause 5 an intention to waive the equitable rights?
Yeah.
And in my submission, you simply can't. This is simply a recognition of the commercial reality that exists today. Might have been very different 100 years ago. And it is the same in my submission as what happened in the case Lord Justice Millett is referring to, where when the vendor allows on sales to sub-purchasers, it has simply postponed its vendor's lien against those purchasers, just as Candey have against Campion Maverick, although I take Lord Stephen's point, they couldn't enforce it, but have not waived the lien against PHRL, which is what, my Lord, you're looking for. Now, my Lord, as far as Lord Briggs's point, that he put to me this morning about groom and cheese rights, as far as that is concerned, Lords, the first point is that, as we both accept, intention is to be determined objectively, so that any evidence by either of the parties as to what they intended is irrelevant. But, my Lords, whilst the question of intention is to be determined objectively, intention itself is, of course, subjective. So you're doing this rather strange exercise of objectively trying to find out what somebody's subjective intention is. And on that basis, the deed of charge, and you're doing it at the time that this additional security is entered into. The deed of charge expressly provided for a fixed charge.
Well, so it did in, was it Toshuka? Which was the Supreme Court case, or the House of Lords case that got the law back into order so far as concerns the difference between fixed and floating charges. No, it's not Toshuka, it's the one after Agnew.
Spectrum is what?
Spectrum Plus, yes.
Yeah.
So it did in Spectrum Plus.
Yes. Yes.
It said it had fixed charge sort of plastered all over it, but
Yes.
it wasn't effective to make it a fixed charge.
No, but the exercise your lordships are embarking upon is to say, in October, when this deed of charge was entered into, what was the intention of the parties? And on the face of the document, it was that there should be a fixed charge.
We say, when you say that, that's a label the parties use, but when you looked at the substance of the thing, it was a floating charge.
In the events that had happened, in the event that the company had gone into liquidation, and then the issue is raised, yes, I accept, and I do accept that His Honour Judge Davis White found it was a floating charge as a matter of construction.
Not because of some statutory consequence
No.
arising on liquidation. It was always a floating charge.
Yes. But what your lordships are looking for is the intention of the parties.
If I confer upon you a right to occupy premises, which is in law a licence, my intention is to give you a licence. I can call it a lease till I'm blue in the face, but my intention, objectively construed, is to give you a licence. Or vice versa.
The difficulty I have with that, my lord, is the fact that intention itself, I accept that it's to be objectively ascertained, but intention itself is you're objectively ascertaining what somebody's subjective intention is. And at the date that this was signed, objectively looking at it, the intention, no doubt that this wasn't the result, I accept that, I accept what His Honour Judge Davis White says, but the intention was for there to be a fixed charge. And, my lords, this is very different, in my submission, from groom and cheese right. Because in groom and cheese right, the solicitor drafted the security. It provided for Mr. McCall to be the trustee, and it provided for Mr. Call to be paid his costs and expenses. And whilst this wasn't the ratio of the judge's decision, one can see that on the facts of that case, there was an inconsistency between the solicitor on the one hand saying, I agree that it's agreed I have a charge, it's agreed the trustee be appointed, it's agreed he gets his costs and expenses, and on the other hand saying, no, I come out on top and I get paid first. But all of that was known to the parties at the time, and plainly one can see that the intention of the solicitor was that he get this charge and the recoveries be provided to the trustee. One can't get that intention from this document, from the deed of charge. It is factually different. And in my submission, you can't infer an intention to waive the lien. My lords, if I can go on to the question of interest, this really is a short point. The difference, what one's comparing, and again I stress it's not a spot the difference exercise, is the rights that the solicitor has under his retainer with the rights he has under the new security. And that's clear indeed from Lord Briggs's judgment, paragraph 66 in Gavin Edmondson. And in our case, the right to interest arose under the fixed fee agreement, which is the retainer. And therefore, there is no... I do
apologise. I thought the contrast was between the right to interest under the lien and the right to interest under the charge. And my understanding, and I'm not certain whether you agree with it, the lien does not cover interest. And,
I don't agree with that,
yes.
but I'll deal with that in a minute.
Okay, I'm sorry.
But on the big point, if I can put it like this, our right to interest arose under the retainer and not under the charge. The deputy judge agreed with us, and that's paragraph 116.2 of his judgment. The Court of Appeal disagreed, but in my submission, they were wrong to do so. In the Court of Appeal judgment, it's dealt with in paragraphs 75 to 77. And in effect, what her ladyship is saying is that she's considering the fixed fee agreement and the deed of charge together as a new arrangement. Well, yes, they were. Well, one sees that from clause 1 of the fixed fee agreement. But that's not to the point. What matters is what was Candey entitled to under its retainer, and the answer to that question is interest. Now, dealing with Lord Stevens's point, it's right that my learned friend says interest is not covered by the lien. They don't cite any authority from that proposition. They refer to Section 83 of the 1974 Act. It should be Section 87, which is in the supplemental bundle. But I don't think we need to look at it. That defines costs as including fees, charges, disbursements, expenses, and remuneration. And in our submission, that's clearly broad enough to include contractual interest. And indeed, in Solent number 2, Mr. Newgee doesn't suggest that interest is not covered by the lien. He simply finds that interest at 15% was unenforceable. And there's no suggestion in our case that Candey's right to interest was unenforceable. What you do have, just to be fair, so we did look at it, but in Solent number 1, I don't think we need to turn it up. I'll just turn it up so I get it right. We looked at this morning. Paragraph 35. Mr. Marshall further submits page 485.
Thank you.
Mr. Marshall further submits that the initial question is not whether interest was otherwise payable, but whether or not it could be secured by a charge. He points to the terms of Section 73(1)(a), which provide for a charge for his tax costs, and to Candey Ltd's formulation of the test in Re Morris that the legal charge is inconsistent. Mr. Marshall appears to be right that a charge under Section 73 does not secure interest. Now, my lords, I don't agree with that. In our submission, interest is covered by the charge. But I think, but what is important for these purposes is what Mr. Justice David Richards, as he then goes on to say. I think that Mr. Marshall is reading Candey Ltd's formulation out of context. The test referred to is whether the security confers a right to interest which would not otherwise be payable. And in our case, the right to interest would otherwise be payable because it's contained in the retainer, in the fixed fee agreement, and not in the charge.
Why does all this turn on the Solicitors Act? The Solicitors Act has a sort of statutory way of, as it were, putting into black and white what the solicitor will already have from the outset as an equitable lien.
Yes.
The real question is whether the equitable lien covers a contractual provision for interest, isn't it?
Yes.
Is there anything apart from dicta and Gavin Edmondson which answers that question?
Well, I was going to say the only authority I'm aware of is the dicta in Gavin Edmondson, which is it governs the rights under the retainer.
Yeah.
Which in our case covers interest.
And I have to say, I don't think anybody was thinking about interest in Gavin Edmondson.
No, that may well be right.
Maybe one of those torrential observations that might have had unrealised exceptions. But there's nothing on interest in relation to equitable lien, is there?
No, not as far. I mean, we'll check overnight, my lord.
Right.
But as far as I'm aware, there isn't anything. But I mean, you know, I've referred to paragraph 66, I think, in your judgment in Gavin Edmondson, but also in paragraph 3, which we cite. Your lordship describes the lien as securing the amount contractually due to the solicitor.
Yes.
Which includes the right to interest. But my lord, the final inconsistency relied upon by my learned friends is the right to appoint a receiver. This did not form part of the Court of Appeal decision, see paragraph 78, and was rejected by the Deputy Judge in paragraph 116.4. It doesn't feature in the agreed statement of facts and issues, and that's why it's not addressed in our case. But it is addressed very briefly in the respondent's case, paragraphs 146 to 148. As to those paragraphs, it was only raised in correspondence by Candey when Candey thought it had a fixed charge. And just for your lordship's note, the reference to that is page 359 of the core bundle. But, my lords, the statutory right to appoint a receiver under a floating charge is something that does not arise under the charge, on the face of the charge. It arises by statute. Under the equitable right, a solicitor could apply to court for a receiver in respect of its lien. Section 73(1)(b) expressly confers upon the court the power to make such orders for the raising of money to pay the solicitor's costs or for the paying of the solicitor's costs out of property recovered or preserved as the court thinks fit. That would include a power to appoint a receiver. And of course, there's the power in Section 37 of the Senior Courts Act. So that under the equitable right, there's a statutory power to appoint a receiver. Under a floating charge, there's a statutory power to appoint a receiver. And just one point on paragraph 148.2 of my learned friends.
The equitable right simply entitles you to go to court for enforcement remedies.
Yes.
And that might include, I suppose, an order for sale or the appointment of a receiver for the rents and profits. That's what you're saying?
Yes.
Yes.
Yes. My lord, it's a small point, but in 148.2, my learned friends say the Privy Council held in Bank of Africa against Salisbury at 284 that a new agreement which confers new and special powers with respect to part of the subjects covered by his original lien will discharge of the lien. In fact, if your lordships look at the Bank of Salisbury case, it's page 405 of the authorities bundle, their lordships say may discharge. And to some extent, it's a question of degree. But in my submission, the power to appoint a receiver exists both under the equitable right and under the floating charge. And in any event, even if it didn't exist under the equitable right, it's simply an additional right that can exist in parallel. It's not an inconsistency from which you can infer an intention to waive. So, my lords, if I can move on to reservation. Your lordships have seen the references this morning to implied or inferring a reservation. Lord Reid pointed out the reference to it having to be expressed by Mr. Nugee. My Lords, in my submission, it is possible to imply a reservation, and that's what the Deputy Judge found in paragraph 117.1 of his judgment. My Lords, whether or not that's the case, it is unnecessary to reserve the lien, to expressly refer to the lien itself or to section 73 or anything of that like. As the Court of Appeal recognised in paragraph 91 of its judgment, it's commendable to avoid legalese. Now, my Lords, I really don't want to spend a lot of time on this because it's simply a question of reading clause 7 of the fixed fee agreement. Any monies recovered by PHRL from the date of this agreement, whether for costs or otherwise, will be applied by Candey towards the outstanding costs and or the fixed fee and or disbursements at Candey's discretion. Now, in my submission, that is a clear reservation and reference to the rights under the lien. It is simply saying any recoveries will go to Candey. Now, that can't be a reference to the deed of charge because of paragraph 5 and the reference to the bona fide rights of Campion Maverick. It can only be a reference to the lien. And when you factor into that, the reference in the cases Hames and Cooper, etc., to the effect that everybody's deemed to know about the existence of the lien, and you factor in that PHRL were told to and did take independent legal advice, in my submission, that is the end of the matter. My learned friend's answer to that, which found favour with the Court of Appeal, is that it's a reference, or all clause 7 is doing, they say, is it reverses the usual rights of appropriation.
Reverses, did you say? Yes.
Yes. Yes. But, my Lords, that can't be right, because the right to appropriate can only arise if there's a prior right to receive the monies. And indeed, my learned friends accept this because in paragraph 109 of their case, they say, clause 7 of the fixed fee agreement presupposes that Candey has an entitlement to receive any monies recovered by PHRL from the date of this agreement, whether for costs or otherwise. Absolutely right. That is what clause 7 presupposes. It is a reference to the lien. And the right to appropriate can only arise if Candey have that prior right. And that right can only exist under the fixed fee agreement and not the charge because of paragraph 5. If clause 7 really was dealing with appropriation, it would say something like, any monies received or paid by Candey, it would refer to any monies received or paid to Candey, not any monies recovered by PHRL. So, my Lords, in my submission, clause 7 is a sufficient reservation of the lien. One adds to that what Mr. Candey told the client, and this is at page 372. This is in his witness statement at page 372 of the core bundle. He says, I explained to PHRL's director that Candey would be paid first from any fruits of litigation, and I believe she understood this. The judge and the Court of Appeal did not reject that evidence. And again, what more could Mr. Candey say? Yes, he could have said, and by the way, that right arises under section 73, and it's an equitable right until there's been any recoveries, but there's no need to do that. He was explaining the effects of the lien. just like Clause 7 is. And, my Lord, finally, in this respect, we do rely upon what we call paragraphs 5 and 6 of the deed of charge. Paragraph 5 we've already looked at. PHRL irrevocably agrees and instructs Candey to act with full powers to ensure that any monies or benefits arising or payable in any court proceedings in any jurisdiction shall be paid directly to Candey. And then one has the postponement that we looked at just now in relation to Campion Maverick. And then 6, in the event that any of PHRL's rights, title or interest in or to any monies or benefits covered by this deed are assigned or awarded to a third party by court order, or such monies are otherwise paid to a third party, that third party shall receive such monies subject to this deed and subject to the discharge of all liabilities to Candey pursuant to the fixed fee agreement. Again, that can only be a reference to Clause 7 and the equitable lien. So, my Lords, even if, under the first stage of the test, an intention to waive could be inferred, Candey has reserved its rights under the lien. And, my Lords, if I can move on to the question of post-liquidation waiver, it's dealt with in paragraphs 117 to 128 of our case. The Deputy Judge found that there was no waiver because there was no need to refer to the lien because everyone is deemed to know about it, and that was a complete answer. I see Lord Briggs is shaking his head.
Sorry.
The Court of Appeal disagreed with that. And that then raised the question whether or not the rights under the lien must be referred to in the proof of debt because of Section 214 of the BVI Insolvency Act. And the Court of Appeal said that's a pretty tricky question. We don't need to decide it.
But the reason that you have to identify your security in a proof of debt is not because the other side may not know you've got it, but because you have to elect whether you're going to rely upon it or not.
Yeah, and value it.
Yes, and value it, yes. So the fact that they may have known there was a lien, I mean, I'm just reacting to the Deputy Judge's analysis.
Well, my Lord, we do maintain the argument. Let me just put it like that. And it's there in our case, and we rely upon what the Deputy Judge said. I mean, there is probably not a good analogy, but just a lien does not have to be registered as a charge. Indeed, it can't be, because it's not created by the company. So there is a certain sort of consistency there in saying, well, you don't have to register it as a charge. Indeed, it just simply doesn't fall within Section 859A of the Companies Act. And in those circumstances, one can see it is perhaps not that surprising if you don't have to refer to it in your proof of debt. But my Lords, let me move on to the point that wasn't addressed by the Court of Appeal.
I should say, Mr. Lord, that although you're short of time by the clock, it's up to you if you want to run over and eat into your reply time.
I understand, my Lord. And Mr. Holland very generously said, don't worry about the time. We've got plenty of time. Now,
I did say he could eat into his reply time. I'm not that generous.
Section 214 of the BVI Insolvency Act. My Lords, this is in the bundle of authorities.
Yes.
Tab 33, page 821. Subject to subsection 2, if a secured creditor omits to disclose his security interest when submitting a claim in the liquidation of a company, he shall surrender his security interest for the general benefit of the creditors. So that raises the question, what's a security interest?
Just before we leave it, I take it that no application was ever made under Section 2142.
Page 817, security interest includes a charge and a lien. And then page 819, section 9.2, a creditor is a secured creditor of a debtor if he has an enforceable security interest over an asset of the debtor in respect of his claim. And my lords, it's the word enforceable that we rely upon. At the time of the liquidation, there had been no settlement. That happened a month later. And at that time, when the proof of debt was submitted in February, there had been no settlement. So that there were no recoveries and nothing that Candey could seek to enforce their equitable right against.
Could they have prevented them from creating a charge over it?
Well,
or assigning their interest, whatever it might be.
They had a right. I mean, that's clear from Lord Briggs's judgment in Gavin Edmondson. They had this equitable right.
I was just interested to understand. There's nothing that they could actually recover the money. But could they take action to prevent the money, if it did emerge, from being given away, for instance?
Well, insofar as it was monies in court, there was no risk at all. Oh. But I mean, there is the right. I refer to that in the context of appointing a receiver. Hypothetically, it may be that a solicitor, before there are any recoveries, he has the equitable right that Lord Briggs talks about in Gavin Edmondson, and in my submission, it is conceivable that he could apply to court for some kind of protection if he was worried that, for example, his client was managing his affairs in such a way as to ensure that any recoveries that came in would not be amenable or available to the solicitor. But that's not the question here. We are looking at this statute, and there has to be an enforceable security interest. And in my submission, it is clear that as at the date of the liquidation, as at the date of the proof of debt, Candey did not have an enforceable security interest.
Is there anything in the BVI Insolvency Act about the proof of future or contingent debts?
There is a reference to the definition of assets, which is at 812.
812, thank you.
It's in section 2. Asset includes money, goods, things in action, land, and every description of property wherever situated, an obligation.
Present or future.
Yeah.
No. But the process of proof with which we are here concerned.
Yes.
Does the proof of debt require you to identify future and contingent debts? Because if it does, it wouldn't be terribly surprising if it also required you to identify future and contingent securities.
My Lord,
or rather, present securities over future or contingent property.
My Lord, one has to look at section 211.
Right.
Now, section 211, most of it appears in the further 3 pages that were submitted by my learned friends solicitors on Monday.
Right.
So I don't know where your lordships have put those 3 sections, or those 3 pages. It's section 212, 213, and then section 152.
Yeah. Section 211, you say?
Yes, but if you can find the first page of what was sent through, it has, halfway down, it has section 212.
Yes, we've got,
right.
It's a 2-page bundle, yes, that's headed up AB 100,
I've got it.
1983.
Yeah.
Yeah, now, what we don't have, we do have in court, but we can send it overnight if you want. We don't have section 2111, but that reads, if I can just tell your lordships, a secured creditor may value the assets subject to the security interest. And then you have what we do have, a secured creditor may at any time apply to the liquidator to amend the value that he or she placed on the security interest. Now, I just pause there, because 2111 talks about valuing the assets subject to the security interest. But 2112 talks about the value he places on the security interest. But as far as Candey are concerned, as at the date they submit their proof of debt, they simply don't know what the value of the security interest is. There have been no recoveries. They don't even know if there's going to be a settlement. The claim was for the shares and also for damages. They might have recovered it if it had gone all the way to trial. Your lordships may have seen reference to Mr. Brisby thinking that it was a great claim and was going to succeed. They may have recovered a lot of shares and a lot by way of damages. But they simply didn't know at the time the proof of debt was submitted what was going to be recovered, and therefore couldn't put a value on it. If one reads on 2114, if a liquidator is dissatisfied, he may require the assets comprised in the security interest to be sold. But how? Nobody knows what the assets are going to be. And
it's a possible answer. You have to disclose your security, but insofar as it's over contingent assets, you may at that stage have to value it at nil, but subject to a right to come back and amend the valuation if assets materialise.
No, my lord, you have to disclose an enforceable security.
No. I'm just, it's part of analysis of whether enforceable means what you say it means.
Yes, but I mean, I'm taking your lordships to this to show that enforceable means presently enforceable. My learned friend says it doesn't have to mean presently enforceable because of the reference to contingent assets in the definition of assets. But this regime simply doesn't work in relation to the kind of security that Candey had pre the settlement. And then 2121, a liquidator can redeem at the value placed on the security interest. Well, again, no value can be placed. There can be no question of redemption until something has been recovered. And, my lords, for completeness, we have some, but not all of the relevant insolvency rules here. And I refer to those because your lordships may have picked up that in an order of Mr. Justice Hilliard, one of the recitals said that the parties accepted that English BVI law was, in all material respects, the same as English law. And we do set out some of these provisions in our case. But under the English insolvency rules, they're in tab 32, page 823. But again,
page number, sorry? What?
822.
Thank you.
What your lordships don't have, and again we can get these to you overnight, but this is not contentious. Rule 14.3 provides for the submission of a proof, and 14.4 says that that must contain the value the creditor puts on any security. And then 14.16, which is on page 823, is the equivalent of section 214. If a secured creditor fails to disclose a security in a proof, must surrender that. But then 14.7, liquidator can redeem at the value placed. And 14.18, if the liquidator is dissatisfied with the value, he may require any property comprised in the security to be offered for sale. So in England, you face the same difficulties, because until there is a recovery either by way of settlement or judge a satisfied judgment, you can't. And that's why, in our submission, the word enforceable in the definition of security interest is important. And for good reason. It simply doesn't work in relation to a solicitor's equitable right unless and until there has been a recovery and something for that equitable right to apply to. Now, my lords, I'm looking at the time. Abuse of process. The Court of Appeal didn't decide, as I said earlier, did not decide this point or the question of discretion. The Lady Justice Rose said in paragraph 95 that her inclination would have been the same as the trial judge. The trial judge sets out his reasons in paragraphs 139 to 150 of his judgment. And perhaps I think I don't need to take your lordships to it. I'm sure you'll read it in due course. The judge was right, though. This case does not fall within the Henderson and Henderson category of abuse. The liquidators' application was precisely that. This is their application for a declaration that it was simply a floating charge. It was an application brought by the liquidators, not by Candey. The existence of the Section 73 lien was not, in and of itself, a defence to the claim that the deed of charge was not a fixed charge. Indeed, and this is a point I made this morning, until Candey lost and it was decided that they only had a floating charge, the question of the lien was entirely academic. If Candey had won, then there would be no need to decide whether or not it had a lien. As is clear from the authorities, for example, Solon number 2, at paragraph 22, the circumstances must be exceptional to deprive a solicitor of his lien. And again, I make the point, everybody, the Haynes and Cooper point, everybody's deemed to know about the lien. But my lords, in my submission, the important point is it would have made no difference if Candey had not waited until March 2018, but had raised the existence of the lien earlier. It is clear that the liquidators would still have disputed the lien, and they would have also disputed that the charge was a fixed charge. Both those issues had to be decided. So there would have been no saving if it had been raised earlier. Perhaps one could say, well, there might have been a little bit of case management and maybe they might have been decided in a different order. But to some extent...
Altogether.
Well, altogether, but they are discrete issues. I mean, yes, of course, they could have been decided at the same hearing, but all of the same arguments that were ventilated before His Honour Judge Davis White in relation to the fixed or floating charge, and all of the arguments that have been floated before your lordships, the Court of Appeal and Mr Hockhauser in relation to the lien, would all have been ventilated. My lord, there's one authority in this respect, and that is Henley and Bloom. That is in tab 68 of the authorities bundle, page 1365. And my lord, I'm just conscious of the time. Can I just point out the relevant bits?
Yes, of course.
If your lordships were to read the head note, what there was were possession proceedings were brought against the claimant, who resisted on grounds that it would not be just and equitable to order possession because he had carried out repairs to the flat costing over £10,000. That was settled by a consent order, and it was after that that the claimant issued proceedings against the defendant claiming damages for breach of her statutory repairing obligations. And the point was taken, well, you should have raised all of that earlier. And the Court of Appeal said no, and in the judgment of Lord Justice Neuberger, paragraph 16, page 1370, he refers to Johnson and Gorwood and explains what is meant by abusive process, and paragraphs 17 to 19 are relevant in that respect. And then in his reasons, the bits I would particularly highlight, paragraph 28, my first principal reason is that the two claims involve different issues. Same here. And then paragraph 30, if the possession claim had proceeded to trial and had failed, it would have been impossible for Mrs. Bloom to establish that the disrepair claim was an abuse. Yes, correct. Paragraph 32, Mrs. Bloom should have been aware of the possibility of a claim. We would say the same here because of Hames and Cooper. And then paragraph 33, the claim was brought by Mrs. Bloom and no counterclaim. The same applies in relation to the liquidators application under the in relation to the fixed or floating charge issue. So, my lords, in my submission, there is no basis for any finding that the failure to raise the lien earlier amounted to an abuse of process. As far as discretion is concerned, my learned friend relies upon the same facts in effect. But we have the added point that, of course, this was an exercise of discretion by Mr. Hockhauser and should only be revisited if he went wrong as a matter of principle. And in my submission, when your lordships read the relevant paragraphs of his judgment, he didn't. And that Lady Justice Rowe's inclination was entirely correct. So, my lords, gone 13 minutes over. That will be taken off, I assume, my right to reply. But, my lords, unless I can assist you further at this stage.
Well, thank you very much, Mr. Lord.
My lords,
yes,
would it be a convenient moment now for a 2 or 3 minute break for the transcriber?
Yes, certainly. Yes, we'll adjourn for 5 minutes. Mr. Holland.
My lords, can I briefly get my jury points in first? In paragraph 2 of our written case, we direct your attention to all the sums which Candey have already been paid pre and post liquidation.
Yes, it is a jury point, isn't it? However eye-watering the amounts may be.
Well, it's simply this, that if you then combine that with what is set out in the letter of the 22nd of February of this year, to which my learned friend drew your attention, it is likely that even if Candey lose this appeal, they will be paid all of the sums which they are due, assessed as their reasonable costs on an hourly rate. What they seek to do here is bump themselves up the waterfall for those extra costs, which are the remains of the fixed fee agreement, which are, by their definition, not reasonable costs assessed on an hourly basis. Secondly, for what it's worth, we don't accept that if they win this appeal, there will be no question but that they will recover all of their fixed fee, because the solicitor's lien covers costs of the English proceedings only. It doesn't cover the costs of any of the other proceedings which they were engaged upon. Its costs, well, if you look at section 73, that's the way it's defined. The courts, we would say the courts are courts of England and don't apply to, it doesn't apply to, for example, the gin paying arbitration, cost of the gin paying arbitration in Hong Kong. It may or may not matter. I see Lord Briggs looks quizzically at me.
I'm just wondering what the law about equitable lien is in Hong Kong.
Fortunately, I don't have to address you on that, my lord. Can I start with pre-liquidation waiver and some what I thought were uncontroversial points, but may not be. First of all, the solicitor's equitable lien has been recognised in the courts of this country for over 200 years. Welsh and Hole is the case that is generally cited at that, and my Lord Briggs discussed the relevant early authorities in paragraphs 30 to 37 of his judgment in the Gavin Edmondson case. Secondly, it has for almost as long been recognised that the solicitor's lien is capable of waiver, and we submit capable of waiver in the same way as other liens. Cowell and Simpson, although that was a case of lien over papers, if you look at the judgment of that, can I ask you to look at that, please? You've been to it before, but I'll ask you to read a substantial part of it because I want to return to it on the general principles which are applicable here. It's at the Authorities Bundle, tab 11, page 528. And my lords, I don't know whether you want to read it to yourselves now or whether at your leisure, but I would draw your attention to most of the judgment in that case, starting at the bottom of 529 and going on to 530 and 531. I will draw attention to that for two reasons. First of all, because if you look at the bottom of page 530, although above that Lord Eldon deals with the solicitor's possessory lien, he then goes on at the bottom of 530 to 531 to deal expressly with the equitable lien. So he's not confining his comments simply to the possessory lien. And it's page 281 to 282 of the English reports, but it's 530 to 531. And if you then look at the way he describes the effect of it, he expressly says it refers to things like the special contract superseding the implied contract. And I'll come back to that. But we say that's effectively the principle which is applicable here. But the point for present purposes, immediately, is that in that case, Lord Eldon dealt not only with the solicitor's possessory lien, but also with the equitable lien. And we say that for that length of time at least, it's been recognised that the solicitor's equitable lien is, for the purposes of waiver at least, treated in the same way as other liens. As we say, Cowell and Simpson, if you look at 528, Lord Eldon describes it as established by analogy with other cases of lien, and Groom and Cheesewright is a 19th century case which applies the doctrine of waiver to the solicitor's equitable lien. In the light of Mr. Lord's attempt to distinguish in principle, as I saw it, between solicitors' possessory liens on the one hand and the equitable liens on the other, it's important in our submission to focus on the fact that in addition to the solicitor's equitable lien, there are a number of other equitable liens or security interests arising by operation of equity. And we refer in our written case to passages in Snell, which are at divider 111, page 2038 of the authorities bundle. But there's the unpaid vendor's lien, the purchaser's lien for the deposit, and the company's lien over its shares. And in our submission, the courts have hitherto applied the same principles as to waiver in respect of those equitable liens as they have in respect of the solicitor's equitable lien. And as we submit in paragraph 11 of the case, it's entirely right that, in the interest of consistency and coherence, a uniform approach to waiver is applied across all the different types of security interest that arise by implication of law, and particularly in equity. And that's what the courts have done. We cite a case of Hewison Mickle, which I won't direct your attention to, but is at divider 70 of the authorities bundle, page 1402 at 1404. And that's a case where Cowell and Simpson, the principles in that case we just looked at, was applied to an insurance broker's possessory lien. But perhaps more importantly, is the Bank of Africa case. And can I direct your attention to that, please? That is at divider 2 of the authorities bundle, page 402. That was a case of a lien which arose in favour of company over its shares, which arose by reason of its articles of association.
It's normally expressed. It's not implied by law, I don't think.
No, but it's an equitable right. Yes, it's an equitable charge. But yes, I accept it. It's one that arises slightly differently in that it's an express from the articles. But if you look, for example, at page 403, you will see the submissions of Phipps and Beale, QC and Methold for the appellant. And at the top there, you see reference was made to Cowell and Simpson, Mason and Morley, Brettle and Burdett, Hooper and Gum, Angus and McLachlan, and in Ray Taylor. Now, those are cases. Cowell and Simpson is one we've already seen. That's a solicitor's lien over its papers. Mason and Morley you don't have, but that's a pledge of title deeds. Brettle and Burdett is at divider 44, page 964 of the authorities bundle. That's an equitable charge of a trust estate. Hooper and Gum you don't have, but that's a mortgage of a ship. Angus and McLachlan you don't have, that's an innkeeper's lien. And in Ray Taylor is the case you've looked at extensively, that's the solicitor's lien over papers. So all of those cases were cited to the Privy Council.
But are any referred to in the judgment? I can only see Bradford Banking Company and Briggs.
Well, that's true, but then you look at the general principle which is propounded at page 405 at the bottom paragraph. Their lordships do not doubt that a right of lien may be discharged by a new arrangement between creditor and debtor, the terms of which are incompatible with its retention, or by any other arrangement which sufficiently indicates the intention of the parties that the right shall no longer be enforced. An agreement giving the creditor new and special powers with respect to part of the subjects covered by his original lien may be conceived in such terms as to imply that he is not to have recourse against the remaining subjects. But the mere fact of the debtor agreeing to give his creditor authority to sell part of the subjects without notice upon his making default is not, in the opinion of your lordship, sufficient to warrant the inference that the creditor is not to realise the other subject of his security if necessary. So that's a general principle propounded by the Privy Council in that case, which appears to have been done after citation to it of cases of lien, whether be they possessory lien or equitable lien. And the relevant principles in relation to the lien have been recognised, we would say, at the very highest level. There is my Lord Briggs's judgment in the Haven case, which establishes that the solicitor's lien is a form of equitable charge. We will say it's an equitable charge over a contingent or future asset, and we'll come back to that when I deal with post-liquidation waiver. And as explained in the Bank of Africa case, the equitable lien can be waived. And in my submission, that was also confirmed in relation to the vendor's lien in the House of Lords case of Rakpo and Manson. And can I direct your attention to that, which is at page divider 21 of the authorities bundle, starts at page 636. This was a case of a loan which was in breach of the Moneylenders Act, and the lender then sought to say that they could have the money back by reason of subrogation to the vendor's lien. So it's a rather indirect way, but it's the judgment of Lord Edmund Davis at page 115 of the report 656. And he's dealing with a case called Congressbury. And he says this: there's a further ground upon which I respectfully hold that Congressbury should not be followed. It was an express term of the contract in that case that the borrower would execute a legal mortgage in the lender's favour, and that was in fact done. It had early been held in Capital Finance Stokes, case arising from non-compliance 95 of the Companies Act, that in circumstances which I regard as basically indistinguishable from the Congressbury case, the vendor's lien, quote, must be taken to have been abandoned when the contract was completed, for on the happening of that event, the vendor obtained all that he bargained for. Per Lord Justice Harman. In my judgment, the same is true in the instant case. for the charges by way of legal mortgages duly executed and delivered to the appellants were valid and would have been enforceable against the respondent but for the appellant's failure to observe the requirements imposed by the Act of 1927, I'm unable to regard a satisfactory distinction drawn in Cumsbury between that case and Capital Finance and Stokes, nor am I able to see why the reasoning in the last mentioned case, which seems to me to be sound, should not be applied to this case. And that's an express reference to waiver of a unpaid vendor's lien by the taking of security. It's that we'll see, but there's a judgment of Lord Justice Millett, which I'm going to come to shortly, whereby that's where you get all that you bargained for, we say is synonymous in respect of the vendor's lien with taking a security which covers the same property. But we say that is again an express application in the House of Lords, or express recognition in the House of Lords that an equitable lien can be waived in very much the same way, in exactly the same way as a possessory lien. We say that there are three, certainly from the written case, there are apparent three fundamental misconceptions with the appellant's case here. The first, and I deal with them in logical but reverse order of importance. First is that the lien can be waived inadvertently. Secondly, that the principle of waiver of the solicitor's lien is a species of waiver by election. Thirdly, that the basis for waiver of a solicitor's equitable lien is founded on the solicitor's fiduciary duty to advise his client. And it's the way they put that. They say it's founded on the basis. It'll be our submission that, as I think Mr. Lord concedes, that the basis of waiver is the same no matter what lien you're dealing with. Is there some dealing which is inconsistent with a retention of the lien? Albeit that in the case of solicitors, there is superimposed on that test the fact that the solicitor owes a fiduciary duty to his or her client, which in circumstances we say makes it more difficult for a solicitor to retain a lien absent an express retention. I'll deal with each of those in turn if I may. The first misconception, I'm not sure it need detain us very long, is that the lien can be waived inadvertently. You will see in a number of cases, a number of places in their written case, Candey assert that the lien can be waived inadvertently or warn the court against allowing the lien to be waived inadvertently. Paragraphs 2, 37, 39, 43, 1361 are the paragraphs to which reference is made.
Just so as I understand, you say the misconception is the proposition that it cannot be waived inadvertently.
No, the proposition that it can be waived inadvertently is the misconception.
Oh, okay.
It can't. As I think my friend and I agree, the question of waiver is one of intention to be derived objectively from the behaviour or the documents entered into the behaviour of the parties. That intention is either there or it's not. The lien is either waived or it's not. Inadvertence somehow it refers to the subjective intention of one or more of the parties waiving it. In particular, the solicitor here. It can't. The subjective intention of the parties is irrelevant. And I'm not sure Mr. Lord disagrees with that. He appears expressly to agree with it. But paragraphs 64 and 67 of their written case and paragraph 58 of their written case, it's a question of the intention of the parties to be objectively derived. And therefore, it's either the intention is either manifest or it's not.
I may be being very dim, Mr. Holland, but if it's an objective question,
yes,
it must follow that you can waive a lien by your conduct and the words of a document which you enter into without down here or in here actually intending to do so.
Yes. Oh, that's right. You can subjectively be inadvertent, as Candey were, quite clear. Okay. They've never had the courage to actually admit it in court, but that's the case here.
I'm just struggling with the concept of objective inadvertence. Yeah. Maybe I'm just...
Well, that's the point, but that's what we struggled with, and maybe I'm not making it clear, but that's the point. Inadvertence is irrelevant.
Right.
And the objective nature, all that betrays is Candey's ignorance of the lien at the time they entered into the deed of charge in the fixed fee agreement. It's the clear inference which my Lord Stevens said could be drawn. We say it's clear that that's to be drawn. But the objective test also, in our submission, and the court no doubt has this, means that the label that the parties apply to whatever agreement they entered into is irrelevant, in the same way as the parties might label a license to be a lease, but nevertheless it's still a lease, and vice versa. Can I draw your attention to the judgment of Lord Justice Millett in the Barclays Bank case, please? That's at divider 3 to the authorities bundle, page 408. And can I ask my lords to read pages 413 and 414, please, it's letter B on page 420 of the report.
Just remind me, which kind of lien is he talking about?
This is an unpaid vendor's lien.
Thank you. Yeah.
It's the passage begins, the lien arises by operation of law and independently of the agreement between the parties is not dependent anyway on the parties' subjective intentions. It is excluded where its retention would be inconsistent with the provisions of the contract for sale or with the true nature of the transaction as disclosed in the documents, excluded where on completion the vendor receives all that he bargained for. And that's where that phrase that we just looked at in the Irakpo case comes from. And those are the two cases with which the House of Lords was dealing, Capital Finance and Congressbury. That's the speech of Lord Edmund Davis refers to those two cases. And just, again, if I may invite you to read down to 421F, which is 414. My Lords, I'm grateful. I've read out the paragraph at, or the first part of the paragraph at 413 letter C, but there's also the relevant paragraph at 414 letter F. My opinion is clear authority that the intention of the parties is objectively ascertained for the documents they have executed, and that what is required to exclude the lien is that there should be a clear and manifest inference that it was the parties' intention to exclude it. So inadvertence is irrelevant, as is the label which the parties might have applied, for example, in this case, to the deed of charge. The parties intended to enter into that agreement, whatever the legal consequences of that agreement, in the same way as parties might enter into an agreement which is called a lease, but which turns out to be a license at law.
Do you say that what you've just read out applies equally to a solicitor's equitable lien?
Well, it does, save for one point, that if you look at the letter F there, it has to be a clear and manifest inference of the party's intention to exclude it. And if you then go back to E, 420E, the passage from Williams and vendor and purchaser, where Lord Justice Millett says, after dealing with express waiver abandon, the author continues, where such waiver abandon is sought to be implied, the onus lies on those who deny the existence of the lien. Now, we say that alters when one's dealing with a solicitor. Because of the nature of the solicitor's fiduciary duty to an existing client, the onus reverses. The onus is on the solicitor to show why the lien has not been reserved. And it may be...
Well, put that broadly, I don't know how that works.
Well, my lord, the primary submission I'm going to make...
It's not every time a solicitor comes to enforce his lien, he has to prove it hasn't been waived or has been reserved. There must be something which transfers the burden to him.
Oh yes. I mean, it's going to be my submission that the principle in respect of waiver, I think my learned friend agrees, is inconsistent. It's not every security, but once there is a security which is inconsistent, the burden is on the solicitor to show that the lien has been retained. And it may be that, using the words of Lord Justice Millett there, the clear and manifest inference that is required may be less clear and less manifest when it comes to a solicitor. I mean, that's the point that I think Mr. Christopher Newgee QC, as he then was, struggled with in the Solon No. 2 case. How do you superimpose the solicitor's fiduciary duty on top of the principles to do with waiver of lien? Because it seems clear the courts have rightly, in our submission, sought to say, well, hold on, there's got to be some impact of the solicitor's fiduciary duty when it comes to dealing with his or her client. There's got to be some impact on the doctrine of waiver, because the solicitor owes a fiduciary duty to his or her client, which an innkeeper doesn't, and which a purchaser of property doesn't. So how does that have an impact? And we say that it has an impact because it means it's effectively, as Mr. Newgee said, it's much easier to infer waiver in respect of a solicitor's lien than it is other liens. I'll come back to when I make my submission.
In terms of inconsistency or something else?
No, I don't think. It's not my submission that there is. There's less inconsistency required. But once you find inconsistency, it's more difficult for the solicitor to retain it.
Lord, second stage.
That's right. I mean, it's difficult in the sense that, look, we would submit and we accept that a solicitor can expressly retain the lien. For example, suppose in this case there'd been a clause in the deed of charge. The fixed fee agreement and the deed of charge is without prejudice to our pre-existing solicitor's lien, which is hereby preserved. It's full stop. We wouldn't be here. It may be that someone would have tweeted, well, hold on, wait a minute, your solicitor's lien is salvage, that's a first charge, and you're expressly agreeing to a charge behind Candey Ltd. Someone might tweet, hold on, this is inconsistent. I'm going to submit that that's almost repugnancy, quite frankly, when it comes to that. But that is perfectly possible. But it wasn't done here. None of these cases that you see are cases where the solicitor has expressly retained the lien. That's why it gets to court. It's perfectly possible for a solicitor to do that. But
would it be fair to say you accept that express reservation, even by a solicitor, will generally prevail over inconsistency?
Yes.
Yeah, thank you.
I mean, the point, I suppose, is if the solicitor does, as I've said, if the solicitor does expressly say, oh, by the way, I'm retaining my lien, then he probably owes, unless there's independent legal advice, who might then say, well, hold on, there's an inconsistency here, because how's that going to work with Candey and Maverick? How are they going to get paid first? But the solicitor reserve, having said he's going to go behind underneath Candey and Maverick, how does he then retain a right to say, aha, I'm going ahead of Candey and Maverick? And it may be that the solicitor would then owe a duty to explain to the client what the solicitor's lien was, and to say that, well, I know I say I'm going behind the funder here, but actually I'm retaining a right implied in equity to go ahead of the funder. That's why, I mean, you get into all sorts of difficulties if that, but yes, as a matter of principle, I accept that you can expressly retain the lien.
I just have some difficulty with the concept. The test at stage one is whether there is some inconsistency that makes the two incompatible with each other,
yes,
such that they can't sensibly sit together.
Yep.
And you say that because one of the parties is a solicitor, that it's easier to find an inconsistency.
No, I don't say that, my lord. I think, sorry, I didn't make that clear. I thought in answer to my Lord Hambler, I said I don't that the test is the same. Yeah. It's just overlaid on top of that is the solicitor's fiduciary duty. I'm about to turn to that, which I would call...
So what consequence does it have?
Well, we submit that if you find an inconsistency...
What consequence does the breach of the fiduciary duty have?
Well, we say, effectively, if there is an inconsistency, then the solicitor has to make it clear expressly to his client that he is retaining the lien. Otherwise, we submit that Lord Justice Sheeman had it right in that pithy little passage in the Wildblood case. The solicitor owes a fiduciary duty to his client to explain to, if he's doing a deal with him, which includes doing a deal which changes the basis upon which his fee arrangements are made, the solicitor owes a duty fully to explain to the client what's going on. And that would include whether he or she intends to retain his lien. If he hasn't done that, the clear implication is that he must be deemed to have complied with his fiduciary duty. And if he hasn't given any explanation, the clear implication is that he doesn't intend to retain his lien. I think that's I'm summarising what I think Lord Justice Sheeman said more eloquently and more pithily, but that's the point. And it derives, we submit, from, say, I'm moving on to the second misconception, which is that this has got anything to do with waiver, the doctrine of waiver by election, as explained by Lord Gough in the Kanjinjunga. We explain paragraphs 86 to 92 of our written case that this is wrong. It's got nothing to do with that. And you only have to look at what Lord Gough says to see that that's the case. My learned friend didn't take you to that, but it's cited and referred to a number of times in Candey's written case. It's at divider 85 of the authorities bundle, which is at the passage is 1684 to 6. It starts at the bottom of the second column of page 397 of the Lloyd's Law Reports 1684. It's commonplace that the expression waiver is one which may in law bear different meanings. In particular, it may refer to a forbearance from exercising a right or to an abandonment of a right. Here we are concerned with waiver in the sense of abandonment of a right which arises by virtue of a party making an election. Election itself is a concept which may be relevant in more than one context. In the present case, we are concerned with an election which may arise in the context of a binding contract when a state of affairs comes into existence in which one party becomes entitled, either under the terms of the contract or by the general law, to exercise a right, and he has to decide whether or not to do so. His decision being a matter of choice for him is called in law an election. That's not the case here. The classic case, as he goes on to explain, I'm just dipping down the first column. Well, my lord, it's probably best to read both columns on that page, but the one at the bottom of the second column, there are numerous examples of the application of this principle of election in English law. Perhaps the most familiar situation is that which arises when one contracting party repudiates the contract. The effect is that the other contracting party then has a choice whether to accept the repudiation, as it's called, bring the contract to an end, or to affirm the contract, thereby waiving or abandoning his right to terminate it. If, with knowledge of the facts giving rise to the repudiation, the other party of the contract acts, for example, in a manner consistent only with treating that contract still alive, he's taken to have exercised his election to affirm the contract. Now, of course, in those circumstances, the point of knowledge on the part of the party with the choice and clear representation made by party exercising the choice is relevant. If I breach a contract, then you can have a right in a way which indicates that I intend to repudiate the contract or have repudiated the contract. The other contracting party has a choice as to whether to affirm the contract and seek continued performance of it, or terminate it and seek damages. But they will not have been held to have affirmed the contract unless they have knowledge of my breach. And I think Payman and Lanjani goes further and says it's knowledge of the right, that they're rights, and then they make a clear representation to me. But that's not what's going on here, we would submit. If you look at paragraph 42 of the other side's written case, you can see how we would submit that it's simply inapplicable. It's at page 100 of the core bundle. They refer, paragraph 42, page 100, 4 lines down, as referred to above, the two key elements of waiver election are: 1, an unequivocal representation; 2, full knowledge of the relevant facts giving rise to the choice. And then they deal with it in 2 sub-paragraphs. Although in some cases it may be possible to infer an intention to waive, there must in all cases be unequivocal conduct or unequivocal representation. Candey's conduct in this case was far from unequivocal. 2, there's an additional requirement of knowledge. The solicitor must have full knowledge of the facts giving rise to his choice. In this case, Candey could not have had any knowledge prior to the settlement of the London litigation, since it was only following that settlement and the resulting court order that Candey could have known what part of the funds in court, if any, was subject to the lien capable of enforcement of the Solicitors Act. Prior to that, Candey did not have sufficient knowledge to make any meaningful choice between the lien and the additional rights. That's irrelevant. The lien is either waived or it's not at the date the fixed fee agreement and the deed of charge was entered into in, I think it's 21st of October 2015. It's knowledge at that date which, if any, is relevant. And the only relevant knowledge in this context is that of the solicitor. And the solicitor, as my learned friend is at pains to point out, as any fool know, any solicitor has an equitable lien to recover his, to protect his over the litigation proceeds, to protect his costs. But the solicitor knew that, and most solicitors, all solicitors, should be deemed to know that as at the date of the deed of charge. Knowledge at the date of settlement is completely irrelevant to waiver in this context, because it postdates it. And so far as unequivocal conduct or unequivocal representation is concerned, the courts have repeatedly held that it's possible to derive the necessary intention to waive by inference or implication from all the circumstances. In that case, it's inapt, we would submit, to seek to assert that conduct from which one can infer a waiver has to be unequivocal. As we've seen, Lord Justice Millett in the Barclays Bank case said that any inference has to be clear and manifest, but that's different from reference to any conduct which has to be unequivocal. We submit that the true principle here is as follows. We have cited at paragraph 15 of our written case various epithets which have been used to describe what is going on here.
The page number, please.
It's page 142 of the core bundle.
Thank you.
The term most commonly used in the authorities to describe the extinction of the lien such is waiver, although release, loss, abandonment, exclusion and discharge may also be found. If you look at the Bank of Africa case, counsel submitted that the lien had been surrendered and the term used in the judgment is discharge. But all of those terms are synonymous. And the point is this: as Lord Justice Millett made clear in the passage from the Barclays Bank case to which I've drawn your attention, the equitable lien, and indeed all liens, be they at common law or by equity, arise by operation of law and independently of the agreement between the parties. Thus, common law or equity fills the gap left by the parties in circumstances in which the courts have held that it is just or right for them to do so. In relation to the solicitor's lien, as explained by Lord Briggs in the Haven case, equity intervenes to promote what's now known as access to justice.
Independently, if the agreement's putting it quite strongly in relation to an equitable lien, because it's an incident to the contract of litigation retainer.
My lord, that might be right. It's independent of any express agreement,
sure.
I suppose, is the point.
Yeah.
It arises by implication, whether it's by implication of law or implication from the existing arrangement between the parties. It doesn't matter much for this purpose, but I accept that. The point is this, however, when the parties have entered into an express agreement which covers the same ground as the lien, or which contains different terms, then there's no room for the common law or equity to intervene. Suppose put another way, equity follows the law, and equity will not cut across an express agreement reached by the parties by granting to the solicitors rights different to or inconsistent with those the parties have expressly agreed. If you go as far back as that judgment of Lord Eldon in Cowell and Simpson, to which I've referred you, I won't go back to it. He deals with this, he refers to, quote, the special contract superseding the implied contract. Elsewhere he says the express contract determined the implied one. Elsewhere he says the intention to substitute the special contract for the implied one. And finally, the proposition that the lien can exist after such a special contract necessarily involves a contradiction to that contract. Those are all quotes I've lifted from those passages in Cowell and Simpson. And that's the point. It's not a situation where one part or the other is making a choice between two inconsistent rights. It's a situation where you had a pre-existing agreement which had been superseded by another one. And the question is whether the second agreement, the security agreement, is such that there is now no room for law or equity to imply any rights.
If there's a new retainer, as here in the FFA, contemporaneous with the charge, is it one existing agreement being superseded by another? It's just a question of whether, looking at the whole thing, the lien which the law would ordinarily imply into the retainer is capable of standing with the provisions of the charge.
Yes, madam. I suppose it would apply whether the agreement was entered into at the outset or as here during the course of the retainer, during the course of existing retainer, I suppose. I mean, it may be an interesting question as to if, for example, the parties had entered into the fixed fee agreement and the deed of charge right at the outset, in other words, prior to there being any relationship at all between the parties, whether one could say that the solicitor's fiduciary duty applied at that time, given that there was no pre-existing relationship. I'm arguing that in another case, but it doesn't matter here because it's quite clear there was a pre-existing relationship between the solicitor and the client. Therefore, there clearly was the fiduciary duty, the nature of which I'm going to turn to briefly, perhaps tomorrow morning. And therefore that applied. But the point is this. It's not a waiver by election. The question is whether the solicitor can say, I'm relying on a right implied by law or equity in circumstances in which I have expressly agreed an equivalent right or a different right over the same thing. And that's what is at play here.
I thought that you were advocating for the test at page 148, paragraph 33, which is the one in Clifford Harris. That was my understanding of the case that you're making.
Yes, that's right. We say that Mr. UKSC, as he then was, got it right in that, in order to decide whether the equity will grant the solicitor what might otherwise arise from the relationship, that is the equitable solicitor's lien, there has to be some inconsistency in that test applies. But the point I'm trying to meet now is the point that equity election, waiver by election has anything to do with this at all. It doesn't, and therefore concepts of knowledge and unequivocal conduct are completely irrelevant, we would submit. Yes, sorry, I'm pointing out, as we highlight in paragraph 33 there, the test, there's some feature of the security which is incompatible with the lien, such the two rights cannot sensibly have been intended to subsist in parallel. Does the agreement between the parties which they've expressly entered into negative there being any intention for the equitable, the lien arising by equity to continue to exist or to exist at all? I suppose you could say there's a similar and slightly reluctant to draw an analogy, but there's a similar analogy between express and implied terms in a contract, I suppose. A court will not imply a term in a contract if it's either contrary to an express term or is covered, or an express term covers the same point. There's no need. There's a slightly different test, I accept, but it's a similar sort of concept.
But that test concentrates purely on the documents. It doesn't take into account the other circumstances.
True, that's right. I mean, it depends what the nature of the contract is. If the contract's purely written, yes, of course, you look at the you look at the written contract. So it's not an exact analogy, but it's a better analogy certainly than waiver by election. My Lord, I note the time. I think that's subject to anything your lordship has to say. That's a convenient moment.
Very well then. Thank you very much, Mr. Holland. We'll adjourn then for the day and resume at 10:30 tomorrow morning.